Hello everybody, it is the 10th of December 2020 and welcome to our Brexit Day. And I will be talking about Brexit virtual workshops, immigration law Q&A, strategic planning in the UK on the new immigration system. So welcome, my name is Julie Moqtadir and I work at Stone King. Now, if you haven't used this before, what I'd really like you to do is just have a look at the panel, which I think will be on the right-hand side of your screen, and you will see a little section there that says question, and if you click on the questions, you'll see that you can join in, and really that's how I'd like to run this today. I would like you to be able to get involved as much as possible. I'm sure you've got lots of questions and I may not answer those questions, so please shoot them at me. So if you could, oh, Daphne cannot hear me, so I don't know if anybody else can hear me. I'm hoping that you can. Daphne, it may be that you've not clicked on, oh, great, Ian can hear me, Bob can hear me, and Juliana can hear me. So I feel confident that it's working, Daphne. So I think it might be your end. So have a little look around your screen. I think there will be something about the audio that you need to click. Okay, so I can see that a few people have used the question box already. If you could just pop something in there, say whatever you want. Good afternoon, Merry Christmas. I don't mind, but pop something into the question box, and then I know that you know how to use it, and we can all continue happily knowing that you can ask any questions. Brilliant. Good afternoon. We've got, oh, Merry Christmas, Zach. That's a happy one, isn't it? Brilliant. Ken, hi. Carla, Elizabeth, Fiona, brilliant. There's loads of people there. Diane, Samantha, Liz, Lisa. And she can bring on Christmas, and I think we all feel that way. Gosh, what a year it's been. And let me tell you, as an immigration lawyer right now, it is bonkers because the new immigration laws have been introduced, and I know that I'm the one that should be the expert in it all, but we keep unearthing little bits and pieces within the immigration laws that we didn't quite know about. So it is an exciting time as an immigration lawyer. I liken it to in 2012, where we had another really massive change in the immigration laws, and everybody for about 6 months after was just like, what's happening? So it's a little bit like that for now, but it's exciting times and lots of interesting things. Richard, good to see you. So super. Without further ado, let's get on. Right. So today's focus, we're going to try and run through quite a few bits and pieces. I know it's a Q&A, and you're the ones that are giving me the questions. So please do pop the questions into the box, and I will answer them as we go along. I do prefer to have interaction. I think it's better for you guys as well. So the more that you can try and engage with me, the better. So we're going to have a look at all of these topics. You don't need to read them out. They're there, and you will get the slides at the end of this. We'll make sure that we send them on to you. So don't worry too much about writing things down or about trying to photograph the screen or anything. We'll get them all to you. So moving on, and the first question we have are, what are the key changes to the UK's immigration system? Big question, really, because, you know, we've talked a lot, haven't we, about the new points-based system. I know a couple of years ago, Mr. Johnson talked a lot about introducing an Australian points-based system. The fact is, we already had a points-based system. Our immigration system is based on a point-based system, but now we've got a slightly different point-based system. So what they've done is they've chopped and changed and moved around a little bit, which for us practitioners can be a little bit challenging. So the government opened the new system on the 1st of December, early. I mean, what were the chances of that? Quite exciting. And the new rules are already in force for some areas and not for others. So we know that for European nationals, new rules will come into force from the 1st of January 2021. From the 1st of December, we've had changes already to skilled work. So the key changes that you need to know about the tiers. What are tiers? If you don't know what a tier is, good. You don't need to know anymore. Tier 2s, they've gone. We've now got skilled worker route. Tier 4, whether you sponsor Tier 4 general or Tier 4 child, they were always student routes. You don't need to know about the tiers anymore. You just need to know about the student route. We've got rid of the resident labour market test. I know some of you will be going, yes, finally, the resident labour market test is gone. It's not gone for everyone. It's still there for some of us. Religious workers, ministers of religion, we've still got it. Lower salary and skill threshold for workers. That's one of the changes, is one of the key points, and removal of the 12-month cooling off period. So if you're familiar with tier 2 workers having to go out, stay out for 12 months before they can come back in, that's gone. So that's also good news for us employers. We've now got the short-term study route. It was there before, there's a slight change. Educational exchange for visitors. It's a really interesting one that we've just unearthed. We found it within the visitors visa rules. It's an interesting one, particularly for state schools. If you have European students, your ears might be pricking up at this point. It is an important one. And then there's been a relaxing of the switching provisions. And the switching provisions for individuals who are already in the UK, they've got a visa in a particular route, and they want to change onto a different visa. We'll talk about it later. So Fiona, brilliant. Fiona, Pretajon, brilliant. You've given me a question. We're set up for sponsoring non-EU nationals. Will we have to do anything to be able to sponsor EU nationals? Fiona, I'm going to get onto that when I talk about sponsorship. Don't fear. We're coming up to it. So moving on. There we go. Under the new immigration rules, will we need to sponsor EU nationals to work or study? Fiona, it's like I knew you were going to ask that question. Look at that. So there we go. The question's there. So under the new immigration rules, do we need to sponsor EU nationals to work or study? What do we think? Anybody watching? Anybody got any views on this? Have we got a yes, we need to sponsor, or no, we don't need to sponsor EU nationals? Any thoughts, anyone? Yes, Elizabeth, Zach. A lot of people are saying yes, you're absolutely right. So what we do know that European nationals, their right of free movement will end, and it will end at the end of 2020, hopefully with the end of many things in 2020. Let's hope for a good one next year. So free movement will end at the end of 2020, which means that from 2021, from the 1st of January, EU nationals will need to be sponsored coming into the UK. Now, there are obviously some caveats to that. So if they're coming because they're married to a British national, they don't need sponsorship, but they'll need a marriage visa. Does that make sense? But they will need to have a visa where currently they do not. So if you're employing EU nationals, for example, Fiona, do I know what kind of organisation you're at? I don't. And let's guess you're in a charity, Fiona, but you can tell me if you like. So if you're in a charity and you have European nationals who come over for 12 months at a time and contribute to your charity, you would need to offer sponsorship. And you would need to think about whether you need a temporary worker, so what was tier 5, or a longer term worker, so tier 2. So you need to make sure that you're familiar with the sponsorship rules. Do you need to do anything to your license, Fiona? No, you don't. So your license will change automatically. It already will have changed. So if you go into your sponsor management system, you'll see that you've got skilled worker COS now instead of tier 2. So that's one of the changes that's already happened. So for European nationals, yes, you will need to sponsor them if you want to bring them in. But for those European nationals already in the UK, you don't need to do anything. So they must have registered as settled or pre-settled under the EU settlement scheme by the 30th of June 2021. So they must have done that by that point, and then after that, you'll have confirmation of their status. But any European national entering from the 1st of January will require sponsorship, unless they've got some other kind of visa. Okay, exciting. Zahid, good to see you. Can we state in our advert that the role is not suitable for a tier 2 visa role? So we're going to take the tier 2 out there, and you can say that a role is not suitable for sponsorship if it doesn't satisfy the relevant skill level. Of course, it won't be relevant for sponsorship. So yes, Zahid, you can say that in your adverts. Software services. Fiona works in software services, and we employ students and new graduates. Okay, so that's an interesting one. Most software positions are on the shortage occupation list. So we know that you would probably satisfy the SOC codes. You'd be able to satisfy all of that. New graduates, there are also other routes that you could consider. But if you're getting European nationals, Fiona, yes, you would need to think about sponsorship. And Agnes's question here. Hello, I've no audio, and audio options are giving me nothing. That's not really a question that I'm that great with. Not so good with the techie stuff. I wonder if Sam could perhaps pop something. Sam is helping me, my lovely colleague from marketing. Could you possibly help Agnes with that? Agnes, I'm sorry, but if you do really struggle, and you can't hear me right now, if you do really struggle, you can watch it back later. Okay, so I think we've covered the immigration rules and European nationals. So what steps do we need to take regarding our existing EU nationals? And so like I've just said, trying to flick onto the next slide, which is, oh, there we go. So what steps do we need to take? And they need to register under the settlement scheme. So I'd be really interested to know, out of all of the people watching, and we've got quite a few on today, how many of you have actually engaged with the EU settlement scheme? Have you had any involvement with it? Just stick me a yes, we have, or no, I don't know anything about it. I'm waiting for your answers. Fiona, no. Natasha, no. Carla's had, yep, not seen any yet. Okay. So we've got a few people, yes, both settlement and pre-settlement. Brilliant. Great. Oh, Yolanda says yes, quite a bit. But there's a lot of no's there. So that's several communication emails from staff. Brilliant. That's a good one. So there's a mix there of some people have had engagement with it. Mandy says, no, not yet, but we've emailed all of our schools to remind them of the requirements. Good job, Mandy. We've sent out a template letter, Carol says. Excellent. You know, these are really good things that you're doing. Yolanda asked me about au pairs, and I'll come on to that in a moment. But I'll make a note of that, actually. So for some of you, you've not had any engagement. Some of you, you've had a little bit. Some of you, we know all about it. So we've got two different kinds of status. We've got the settlement status, and we've got settled status, and we've got pre-settled status. Settled status is if an individual has been in the UK for 5 years. Pre-settled status is where they've been in the UK for less than 5 years. Now, for us, for those of us working in HR, it can be a little bit tricky because what the Home Office have said is you cannot implore employees to apply for it. So all we can do is we can suggest, we can encourage, we can notify them of this scheme, but we can't say you must do this. Now, it puts us in a slightly tricky position because none of us want to have a civil penalty for unlawful employment. And nobody is unlawfully employing an EU national because all of those EU nationals, if they've been in the UK for a while, they've all got status. It's a naturally acquired thing. And they got that under the EU rules. So you don't need to panic. But what we need to think about is moving forward, well, how do we actually evidence this? So I think those of you, Carol, Mandy, brilliant. Those of you who sent out letters, really good action. If you go onto the Home Office website, there's actually a precedent letter there. And for Stone King clients, we also can give you a precedent letter. It's a really good idea. Send out a letter and to encourage individuals to apply. You know, do you know that this is what you need to do? Now, I know that there are lots of European nationals out there who just are frustrated with it, but nonetheless, it needs to be done. And it needs to be done for all of the individuals within the family. So we suggest that you send out a letter with the key deadlines. We suggest that you then use the employer toolkit to help everybody with it. So we've got a few questions in. How long a period of absence does pre-settled status allow? Is it 4 months? So Elizabeth asked this question. So pre-settled status is when you've been in the UK for less than 5 years. Now, if the UK is your main place of residence, there is no definition as to how long you can be gone for. So if you've left the UK for less than 6 months, I would say if there was a bona fide reason for it and the UK is still your main point of residence, then it shouldn't be any issue whatsoever. The important thing, Elizabeth, is that that individual has applied on the settlement scheme. Bernadette says, hi, Julie. Hi. How soon can you request an extension to a work visa, non-EU, before it ends? Oh, that's an interesting sponsorship one. We'll come on to that. Yolanda, I've not forgotten about you and your au pairs. Gemma Mitchell says, do you think in the future there will be requirements to check staff have gained EU settlement scheme? Yes. So it's a good question, Gemma, because we don't know. The Home Office haven't said to us what is going to happen post 1st of July 2021. So we don't know. We know that EU nationals must register under the settlement scheme, but we don't know what naughtiness may involve if they don't do it. We don't know that yet. And we can we can hazard a guess, can't we, that as employers of EU nationals, there may be some smacking of the fingers if your employees haven't done it. And so that could be tricky, but we don't know, which is why we do want to encourage individuals to do it. We don't want them to get, on the naughty step, or for us to get on the naughty step. So all of us need to do it at this point. We need to make sure that we're encouraging EU nationals. I make sure that all my mates have done it. Lots of people, if they're self-employed, and particularly now, because you used to see the signs on the underground in London, and it used to be on the radio. Right now, it's not around as much because we're all obsessed with the pandemic, rightly so. So all of this has not been on our mind as much, but it's really important that we mention it to any EU national. Have you done it? Have you done it? You need to do it. But do we know what we need to do after that? Gemma, we don't. What we do know is that once an individual has got settled status or pre-settled status, they can then give you a number, a code, which you then use on the Home Office website, and you would then go onto the Right to Work checking service, just the same as you would now, and put that code in, and you would be able to get a picture of Maria Dalvez, and it would say this individual has settlement status, and that's what you would use for your Right to Work check. So right now, that's what we're advising, but we don't know anything about penalties, etc. moving forward. So Yolanda, you asked me about au pairs, and it's a really interesting one, because did you know that you can now sponsor nannies? There is a SOC code for nannies, and they do fall within the correct level. So would families need to be sponsors? Is a great question. It really depends on how long they're going to get that individual over for, and could the family then create a company that has a sponsorship? Potentially, yes. So it's an interesting way forward, and I would say it needs further thought. We've only just discovered, so I'm a trustee of ILPA, the Immigration Lawyers Practitioners Association, and we were talking about this point this week. So it's an interesting point. Nannies now can be sponsored. Does that mean that families are going to set up their own little limited company? Possibly. But I would say it's worth looking at how long they're coming for, what their main purpose of coming for is their main purpose study, or is it to be an au pair? All those types of questions. I think I've answered all of the questions there. Great questions. Will you get the slides, Ken? Yes, I promise you'll get the slides. Okay, so are right to work checks for EU nationals changing? I don't know whether anybody else finds this exciting. I do. I mean, it's interesting stuff, isn't it? Currently, EU nationals can continue to rely on their EU passports. So we know that EU nationals in the UK right now, and until New Year's Eve, are entitled to just rely on their passport. And then they have that 6 months grace period in which to apply on the EU settlement scheme. So their deadline is the 30th of January 2021. So right now, we're just doing what we were doing under the right to work checks. So that goes back to your question there around what do we need to do, Gemma, around right to work checks, and what will the requirements be? Right now, for the next 9 months, 7 months, we're fine. We're fine. Post that, there's a little bit more uncertainty. If an individual has applied already for settled status or pre-settled status, and they're happy to give that to you, then great, happy days. You can log on to the Home Office checking service and you can put the information in. So Elizabeth says, could a French sister rely on her identity card? She has no passport. Yes. So when I say, great question, Elizabeth, good one today. So EU nationals can rely on their EU passport or ID card. So it's the same as it's always been. It doesn't have to be a passport. It can be an ID card. What I would say, Elizabeth, is that French sister must apply under the settlement scheme ASAP, straight away. Let's do it. Excellent. I think I've answered all questions when it comes to right to work checks. I'm just lingering a little bit in case you've got any follow-ups there, but I don't think you do. Okay, so moving on. Our organisation will need to sponsor overseas individuals as a result of the end of free movement. How do we obtain a sponsorship licence? So another quick Q&A going on. Send me a yes or a no through the questions box. Who has a sponsorship licence? If you have a sponsorship licence, send me a yes. If you don't have a sponsorship licence, it's a no. So we've got lots of yeses, lots of no's. No with an exclamation mark. I don't know what that means. Like, no, yay, we don't have to have one. Or yes, we have. Also, we've got a good mix there of individuals with one, and lots of individuals without one. So yeah. I wonder if anybody has applied for any recently. That's quite interesting. Hi, Liz. Good to see you. And quite a few of my clients on here. So, how do we obtain a sponsorship license? So, this is really interesting. I've been knee deep in the new sponsor guidance, which, as you would imagine, is really, really long, as the other sponsor guidance was. It's recently come out, and there are some interesting little bits and pieces there. So where the Home Office previously would ask 4 questions, we now have two key priorities when you want to become a sponsor license. Pretty much follows the same basis as it did before. And so overseas workers will usually be sponsored under skilled worker, and students will be sponsored under student rates. So previously we had tier 2, tier 5, tier 4. And now we have skilled worker, temporary worker, and students. So only independent schools can sponsor students, and that's really important. I think everybody's got that now, but only independent schools can sponsor students. It's an important one for any of you there from state schools, and I'm including academies with that. I'm talking about funding when I talk about state. So state schools, because a lot of state schools will have short-term European students coming in. Some will have longer term, for example, studying in the IB. There are some possibilities around that which we did not know about before. We can talk about that later if we have time. But primarily, we're going to look at today skilled worker and the tier 5 temporary workers. So in order to obtain a license, it's an online application. And I was reading through the guidance, and the Home Office suggests that the application can be completed in 30 minutes. I'm yet to have done that. I know last time I gave a webinar and said this, somebody said, yes, I've done that, which is incredible if you can manage to do it in such short time. Brilliant. So what you need to do is you complete the online application form. You supply the specified information documentation. So there is suitability and eligibility requirements. And with immigration law, you'll find that there's lots of guidance, and it's the guidance that will give us all of the information as to what we need to do and satisfy for the sponsorship license. You then pay the correct fee. And the correct fee, for many of you watching today, will be £536. That is for charities, that is for small organisations, and all schools have charitable status. So that's 536. So if you're from a very large company, then you would be on a 1,476, but we would have a look to see whether you fall within the small or charitable first. So what you need to do is you need to obtain the sponsorship license. When you apply for the sponsorship license, you would also inform the Home Office of any individual that you have that you would like to sponsor. So if you're getting a sponsorship license because you have in mind an individual for a particular role, you would put that in with the application. So we're doing one today, and that's exactly what we're doing. If you're applying for a sponsorship license because you're concerned about the impact of Brexit and you haven't got European nationals, and you want to bring in European nationals, then you wouldn't have to put the names of individuals. You're doing it simply because of the changes that are going to take place from next year. So Hugh asked a question here. And Hugh, I think I got this one through on our spreadsheet. So thank you very much. We have EU volunteers every year. Our sponsor, we have EU volunteers every year between school and university. When I sponsor them next year as Tier 5 charity workers or volunteers, is there any way of paying the immigration health surcharge health fee at the reduced student rate? That's an interesting one. If they are not students or coming in to study, my thought process is no, that would be very difficult to do. But do they come in for I have a few questions with that, Hugh. Do they come in for the full year? What is the purpose of them coming in? Are they charity workers or volunteers, or actually are we looking more at the religious workers? So I think there's a few different points that we could clarify on that, and maybe do that off webinar, or you can stick some questions in, and we can see where we go with it. So when it comes to sponsoring the individual, you get the license, and once you've got the license, you then have to pay the fee for the individual and issue the certificate of sponsorship. And then that's at that point, Once they've got the certificate of sponsorship, they apply for their visa, and that's when they can come into the UK. So that's a rough summary of the system. If anybody wants clarification of that, just let me know. So if you're thinking, for those of you, and I think we're 50-50 here as to who's got a sponsorship license and who doesn't, these are the important questions that I've identified. Does your organisation rely on workers from outside of the UK? So that's an important one, isn't it? Particularly, many organisations would fill a gap with European nationals, and that's not going to be the case moving forward. So if you're thinking this is going to be an issue for us, then maybe a sponsorship license is the best way forward. Is your organisation thinking of expanding? Does your organisation function in a sector where there could be a shortage? And if you are a sponsor, do you need to do anything? So for all of you with a sponsorship license and the possibility that you may have to then start to sponsor European nationals, what will you need to do? And that's really important, isn't it? So if you think, yeah, we often have European nationals who come into the UK just for 1 year, but they will need sponsorship moving forward. Maybe you will need to change your certificates of sponsorship. So that's a really key question for you to think about. Do you have enough certificates of sponsorship on your existing license? And then finally, is your organisation going to change in any way? Are you going to merge? If you're a charitable trust, may you become a CIO? All of those questions you need to consider in terms of a sponsorship license. So I'm now just going to confirm, and I don't know if anybody knows about our Brexit tool, but this question here, and in fact, why don't you just reply if you have used it or not with a yes or a no? Gosh, I need to change that up a bit. But if you've already used our Brexit self-audit tool, stick me a yes. If you haven't, so there's a couple that haven't. It is free to use. It is for businesses, for charities, for religious orders, state schools and independent schools. I think I've covered every type of organisation there. Lots of you are saying no. Go on to the website, the Home Office website. You just need to put in some information and then you're asked a number of questions. We will then send some information through to you as to the key questions that you need to be asking as your organisation. So if you perhaps have trustees or governors that you need to go back to, you'll be able to put all of those questions to them, and it will just help you with this decision making in readiness for Brexit. So have a look on the Stone King website. It's really good. We've had great feedback on it. And that, I think, is it. Gosh, I zoomed through that. I hope I didn't talk too quickly for everybody. I make it that I talked for 30 minutes, which does give plenty of time for questions. So do I have any further questions? What was the tool called on the Stone King website? So the tool, let me see if I can go back. I was testing. Oh, there we go. Look at that. So it's a Brexit self-audit tool. If you, we can send a link to it actually in the email, Zach. So when we email you after this webinar with the slides, I'll send a link to the tool and you'll be able to just click on it. But if you just want to go on our website and search for immigration or my name, you will find the Brexit self-audit tools there. And depending on what kind of organisation you're from, you make sure you choose the right one. Click on it and then you just go through the process. I think it depends on your answers as to how many questions, but it doesn't take too long. But it is really useful for you to make some key decisions. Yolanda, you're very welcome. Taya, is it possible to add allocations in the middle of a COS sponsorship year? And do you know how far in advance we will need to do that? Okay, great question. So if, for example, you have 5 certificates of sponsorship for this year and you have used them all, so if we're talking about regular skilled workers, which were Tier 2 General, you will run May to April in an annual year. This is different for religious orders. Don't panic, your year will be different. But for Tier 2 General, or what is now skilled workers, your year will run May to April. So if you've used 5 certificates of sponsorship by December and you think, I need more, you can put in an in-year request. And so if you go to the request box on your sponsor management system, you will see annual allocation there. So request an annual allocation. You will see above that, it will say in-year request for increase of certificates of sponsorship. Click on that, put your justification in. Now, it can take between 10 and 12 weeks, or you can pop it through the priority service, which you do need to pay the Home Office for. I think it's £200. At the moment, it's by email, and you can get a decision within 5 working days. Taya, that's that question answered. I hope that's useful for you. Does Stone King have a sponsorship license to sponsor international employees? No, we do not, Antara. Anybody else with any more questions? I hope that you have found that useful. I'm just going to linger on for a little bit longer in case there are any more questions. Shoot ahead. Any question will do. We've never conducted right to work checks. What kind of documents showed this? Okay, so that's a good question, Joanna. Right to work checks are essential for every individual. You must conduct right to work checks for everybody within your organisation. And the reason that you conduct right to work checks is in order to obtain a statutory excuse against unlawful employment. So often people will say to me, I'm okay, I've only got British nationals in my organisation. That isn't giving you a statutory excuse. You have to do it for everybody, and you need to make sure that you've got it evidenced. Now, a right to work check properly undertaken means that you meet the person and you see them. Now, at the moment in COVID times, that's very difficult, I understand. And you would then take a copy of their document, you would sign it, make sure that they've got the right to work. There are very good checklists on the Home Office website. So if you're unsure about right to work checks, go onto the Home Office website, make sure that you're retaining a copy of everybody's documents. You are allowed to do that in accordance with GDPR because it's for effective immigration control, which is one of the exemptions. So, Joanna, I would suggest that's your number one action, because the civil penalty against unlawful employment where you don't have statutory excuses is £20,000. So it can be very expensive if you've got a few employees and you've not conducted them. So I would put that as a red on your risk register and perhaps act on that quite promptly. So I've got loads of more questions in and a bit more time. So yeah, we've got 10 minutes. I'm just trying to work out how to make my question box a bit bigger. Oh, I've done it as well. There's my win today. So Zach, I've answered that question about the tool and you're happy. Antara, sorry, no sponsorship license. And Joanna, we've covered right to work checks. So Fiona, hello again. Many students have a visa that allows them to work in holidays. Will there be any changes? Okay, that's a good question. So I've not finished going through the student sponsor guidance, so forgive me. I don't think that there are any surprises there, and I believe that they are still entitled to work for 20 hours during term time and outside of term time, longer hours. So that answers that question. Watch our website, watch my LinkedIn, because if there are any changes to that, then I will always either do an article, send out information, or alternatively, it will go onto my LinkedIn. So yeah, I didn't mention, but do please connect with me on LinkedIn. Becky, I love a question that starts with, this may be a stupid question because I ask lots of them. So sorry to ask a stupid question, but just to be clear, if you recruit a person from the EU on the 1st of January and they tell you they arrived in the UK a few days before, do you have to wait until July to actually check they did apply for settlement without any penalty if they don't? That's not a stupid question, it's a great question. You have to take their word for it. You have to take the European nationals' word for it. So if they say, no, so remember that the cutoff is 11 p.m. on the 31st of December. I arrived at 10:35 on the 31st of December. You just need to accept that. You need to accept it and say, well, you're exercising your your European rights of free movement, and that's absolutely fine with me. We cannot discriminate, and that's what the Home Office has said. So we cannot implore anybody to actually provide evidence of it. So yes, believe them. So Sister Angela is here with, how and where will you apply for a visitor visa from an EU country? So it would always be to the British Embassy. So Sister, all applications of this kind now are online, and we've not touched on visitors visas today, but it is an interesting thing. And for those of you who are wondering about visitors visas, there are some changes to the visitors visas, and one key point that I think you should be aware of is that there is the possibility to volunteer for longer now on a visitor's visa than there was before. So that's an important change to visitor's visa. There is also this opportunity for the education exchange for European nationals who are coming in and perhaps going to state schools. So there are a few permitted activities which were not previously permitted. But yeah, the answer to the question is, where do you apply? It's online, but it's through the MC. So it's the entry clearance. If you type British visa to the UK, you would go straight through to it. Will the audit tool advise on how schools can check teachers through the EEA checking service, which currently we can check through the DofE sign-in system? No, it will. So the Brexit self-audit tool is our opportunity for you to answer key questions about what you need to do. It will not delve into anything about teachers' EEA checking. And now, Cheryl, I think that question may be related to their qualification as teachers rather than their immigration status. And so that would be a slightly different issue, I think, but clarify with me if not. Elizabeth, what about Tier 2 member of religious order? Do these continue? Yes, they do. Tier 2 ministers of religion, Tier 2 ministers of religion will continue, and they're still called Tier 2 ministers of religion. Yes. Will Stone King be doing any webinars on sending UK employees to the EU? No. So the immigration work that I do is into the UK. So unfortunately, I don't talk about going out of the UK. Joanna, you're very welcome. If someone's settled status isn't confirmed before July 1st, will they have to leave their job? No, they won't. If they are entitled to settled status, then they will be entitled to just be here and to work. So Ian's question here, what's the most important thing small businesses should do now in preparation for the end of the transition period? Ian, the most important thing that you should do now is notify your European nationals that they have to register on the settlement scheme. And the second thing you need to do is make sure that your right to work checks are up to date. And the third thing you need to do is to consider whether, and I'm taking you a small business, so this may not be too much of an issue, whether you do rely on European nationals working for you. And if you do, consider a sponsorship license. But if you don't need to rely on European nationals, just the first two. So Mandy has a question for us now. As a school, we often receive applications from European nationals for unskilled positions. It's a good question. It's not applicable just to schools, but it's a really interesting question, I think, this one. So, for example, cleaners, midday supervisors, cooks, etc. Am I correct in thinking from the 1st of July 2021, we would no longer be able to do this, or just not be able to do this for those that moved to the UK from January 21? It is the latter of your answers there, Mandy. Well done, you've answered your own question. So you can take on European nationals in low skilled positions if they are already in the UK with settled or pre-settled status. But new European nationals coming in after the 1st of July, after the 1st of January will not be able to apply for those roles because they would need sponsorship. Zach, you are very welcome. And Lena, we are a UK subsidiary of a European parent company. Often there's movement of staff between countries. Can this continue? Another great question. Now that really will depend on the period of time that they're coming for. So Lena, what we are advising now is let's look at the purpose of the visit and the duration of the visit. If it's a short visit to attend a few meetings, then we would categorize that as a visitor's visa, so long as it falls within the permitted activity of a visitor visa. If it is a longer move, then we would need to look at a different route. So really, we need to look at the purpose and the duration of the visit or the travel. And I think, everybody, that is it for questions. Any more? This is your last minute call for questions. Any more coming through? I don't think there are. I think we've managed to, oh, forgive me, there is. So we've got a few more. Do right to work checks apply to UK volunteers as they are not paid or employed but get reasonable expenses? Again, a great question. So we need to look at the kind of organisation. So Hugh, I understand that you're coming from a religious order, and right to work checks are undertaken so that we have a statutory excuse against unlawful employment for employees. Statutory excuse against unlawful employment. Volunteers are not employed. Therefore, you do not need to obtain a statutory excuse for a volunteer. But, and there's always a but, isn't there? But what you need to do is you need to consider the reputational damage and potential risks to your organisation. What would happen for your organisation, particularly if you're reliant on any kind of grant funding and your reputation is important to you? What would happen if you were allowing unlawful, undocumented migrants in the UK to volunteer for your organisation? Is there a potential risk? So that I'm pushing that question back to you, Hugh. Is there a risk by you not conducting right to work checks to your organisation? If you can happily say there's no risk, I can tell you there's no civil penalty because they're not employed. But the question comes back to you. I hope you feel that answers that one. Bernadette, hi Julie, how soon can you request an extension to work? Oh yes, you've asked me that one and I didn't cover to it, forgive me. So how soon can you request? Well, I think it is 60 or 90 days before. My question to you would be, why would you want to do it too soon? So it's either 60 or 90 days, and I can clarify that. Juliana, if you get a second, can you check? It's buried very deep in the guidance. The question is, why would you want to do it too soon? So ordinarily, with a normal visa, not a sponsorship, it would be 28 days before. The point being, if you've got somebody on a sponsored visa and it runs out, for example, on the 31st of March, why would you want to apply now? Because you've already paid to sponsor them and you've paid all of the fees up to the 31st of March. So I would say, why do you want to do it too soon? I would look to actually try and do it as late as you can, because then you've got the period extended. If there is a reason that you want to do it sooner, why? And I think that's the question. I hope that answers your question, Bernadette. We are into our last 20 seconds before the webinar cuts off. Thank you everybody for joining me today. Brilliant questions as always. I hope that you've enjoyed this little synopsis of the changes to immigration as much as I have. Have a great day. Have a very Merry Christmas. Thank you.